idea considering the state of things, and I'm glad everyone is able to join, and hopefully you're finding this useful doing this in the evening. And if you'd like more things available, please let us know, and we'll try to offer more sessions. So the goal of this talk is to, sorry, let me get this going. My plan for tonight is to focus on just basics of intellectual property, types and rights, the university's IP policy, university resources that are available for you, and since I think a lot of these questions are arising, what sort of considerations related to IP and licensing and getting things out should you be thinking about if you're innovating for, say, PPE designs, masks, face shields, and other COVID-related inventions. And then I'll try to answer questions as we go along, and whatever I don't get to, I'll answer at the end. So for types of intellectual property, there are 4 main types: trademarks, copyright, trade secrets, and patents. Each conveys with it a different level of protection. Trademark really protects the brand name or logo, which is to help consumers identify the source of goods. To keep and have trademark or service mark protection, there has to be a use in commerce, so you have to be making sales. And if you stop use in commerce, you could potentially lose your trademark. Also with trademarks, you can't protect terms that are just merely descriptive. They have to have some sort of secondary meaning or acquire a secondary meaning. The university, for example, has our muscular testudo as a registered trademark. If you see the little R in a circle at the bottom of a mark, that's how you know it's registered with the US Patent and Trademark Office. You don't have to register trademarks though, but if you do get additional protections if someone's infringing especially. If you see just a little TM on a mark, that means that the trademark owner is asserting that they think they have some unique trademark right, but it's not registered yet, or an application is pending. Copyright is a different form of intellectual property also covered by federal law that protects original works of authorship fixed in any tangible form. So if you take a picture, you write something, you type something, copyright attaches. This presentation, for example, once I typed words onto the slides, copyright attaches. Copyright protects literary works, musical works, dramatic works, choreography, plays, things like that. Copyright, though, does not protect the underlying ideas or functionality of something. That's more the scope of patents. Copyright gives the right holder an affirmative right to reproduce, make copies, make derivative works, distribute those copies, perform, display, and transmit. Software code itself is protected under copyright as a literary work, since there was no software in 1790 when these laws came about, but our legislators have fitted in so that software falls under the literary work piece. Copyright, since the scope of protection is limited, that it's really just protecting the words itself, not the underlying ideas, copyright protection can last a very long time. For individual authors, it's life of the author plus 70 years. If it's a company that has created and owns the work, it can last up to 120 years from creation. Originally, I think copyright, along with patents, everything, I think the term was maybe 14 years. But as certain interests lobby Congress, the terms get extended. Disney's known to be a big lobbyist, and every time one of their very lucrative marks is about to expire, copyright term gets extended, though I believe they do have several valuable copyright that are coming off this year or next year. So one thing that was in the news not too long ago, the Happy Birthday song, a music publisher was claiming copyright, charging royalties for it, which is why if you ever went to a restaurant, remember those days, If you went to a restaurant for your birthday and they sang happy birthday to you, restaurants wouldn't sing the happy birthday song. They made up their own songs because they didn't want to have to pay licensing fees for performing the happy birthday song in public. There was some litigation though, and it turned out that it was actually published much earlier than was thought, and so the music publisher lost copyright in the happy birthday song, and now anyone can sing it, perform it, record it, and not have to pay royalties anymore. Trade secrets are a little bit different. There is no federal law. You don't register a trade secret like you're able to with trademarks and copyright. But you can use trade secret to protect things like formula, patterns, compilations, programs, devices, methods, techniques, processes, even things like customer lists are potentially protectable by trade secret. Laws vary a little bit state by state, but generally you have to have some economic value. Whatever you're protecting can't be generally known and can't be readily ascertainable by someone else. It is a crime, though, to steal a trade secret. The point of trade secrets and to keep it a trade secret is you have to take actual efforts to maintain secrecy. So if you go and work for a company or you're consulting for a company, you might have to sign a non-disclosure agreement that says whatever you do for that company is theirs, whatever you learn, you're not allowed to share with others, and you might even be prohibited for maybe a year or so after you leave employment with that company from working for one of their competitors. And all of those things are appropriate to put in contracts for companies who are trying to protect their trade secrets. Some well-known trade secrets, I think the recipe for Coke is probably the most well-known. WD-40 used to be a well-known trade secret until someone reverse engineered it, which that's the risk. That trade secrets, as long as you keep it secret, it could potentially last forever. But if someone reverse engineers it without stealing, then you've lost your trade secret protection. But WD-40 has a really strong brand name, and so they have trademark protection. But the focus of pretty much the rest of what I'm going to talk about and what I deal with mostly on a day-to-day basis are patents, which protect inventions. Many inventors report, these eureka moments where they think of inventions, accidental invention stories, but I think most inventions, especially for university researchers, you're thinking about a problem and problem-solving solutions to that problem, and whatever your solution is, that's your invention. So patent rights. A patent is a right that's granted by the government in the United States through the US Patent and Trademark Office that allows an inventor or the owner to prevent others from making, using, selling, or importing into the country where you have the patent, the inventor's creation without permission. And it's what's known as a negative right, since the patent holder can't necessarily practice his or her own invention. Let's say your invention is an improvement to someone else's patented invention, and in order to manufacture, sell, use the final product, that's the original invention plus the improvement. If you have to use that original invention, you need a license from that original patent holder in order to even practice your own improvement. And so that's why it's called a negative right. If you've followed any of the Samsung, Apple patent litigation, both companies have lots of patents on their cell phones. Both are infringing each other. And in settling their patent infringement suits, they end up doing cross-licensing, which gives the other company permission to practice each other's patented inventions. Patent rights, you'll notice, last for 20 years compared to that longer term for copyrights. Doesn't last as long because the scope of protection is much greater. But in exchange for this limited monopoly that you get for 20 years, you have to include a fully detailed enabling description of your invention in the patent application, so that once the patent right expires after 20 years, anyone should be able to know what the invention is, how to make it, and how to use it. So if you intentionally try to keep a critical piece out of your patent because you want to keep it trade secret, you've sort of ruined the bargain that you've made with the government in getting your patent. And if that's the goal, to keep something secret, then trade secret protection might be a better strategy than filing a patent. In this country, we have 3 types of patents: utility, plant, and design. Most of what you hear about with patents and what we deal with at the university are utility patents. These protect processes, machines, articles of manufacture, or compositions of matter. You also have to convince the patent office that your invention that you're patenting is new, useful, and not obvious. The useful piece is pretty easy to convince. There just has to be some use. And it has to be new and not obvious. That new piece, that novelty piece, means that no one else has done it before. It might be no one else has patented it before, but maybe somebody has sold a product or made it, described it in a publication, even if they don't have a patent on it. The non-obvious piece is a little bit more difficult of a challenge to overcome and convince the patent office. So when you file a patent application, an examiner will review what you filed. They'll do a search and look at the claims in your patent to see if anybody else has done the same thing that you're claiming. And if they've done it exactly how you say, then you'll get a rejection saying this isn't new. But most of the time what happens is an examiner might not be able to find something entirely on point, but they can take combinations of references and put them together and say, well, it would have been obvious to someone of your skill, of someone of your technical area at the time that you made your invention to combine things in the same way that you did to get this invention. And how we respond to those sorts of rejections are by saying, yeah, well, it really wasn't obvious because it took 10 years of research, or we got really unexpected results. This functions so much better, faster, stronger than anybody else previously predicted, or even these references teach away from the result that you end up getting. So that's probably what we spend the most time trying to convince the patent office, that the inventions we're filing on are not obvious over what others have done before. Plant patents, another type of patent which protect asexually reproduced new varieties of plants. The university has raspberry plant patents. We also have our first apple patent that issued a couple of years ago on Antietam blush. There's also design patents which protect the new original ornamental design for an article of manufacture. Things that are protected by design patents, Croc shoes, for example, iPhones. You can see my old phone, the curved corners of an iPhone. Apple has a design patent on that. So if somebody else wants to make a phone with curved edges instead of straight 90-degree angles, they'd be infringing on Apple's curved edge design patent. If you haven't looked at a patent before, you should. I think this is an important part of doing research and literature searches. There's a background, what's the problem that you're solving, brief description or summary of the invention, detailed description, including those details so that someone else in your field could read the patent and know how to reproduce the invention. And then claims, which are written in sort of funny legalese, but it's a description in precise words of the invention that the inventor wishes to protect. So a little bit more about novelty. Remember those 3 requirements: novelty, utility, and non-obviousness. So certain actions that you yourself might take as an inventor, you could potentially ruin novelty for yourself if you go to file a patent application. So things like publishing, posting online, posting a preprint online, even if something hasn't been reviewed yet, having a thesis published, posting something on a website, going to a meeting and giving a presentation, having posters up in a building on campus, for example, that's open to the public, and having something offered for sale or on sale destroy the novelty requirement. What's good though in the United States though is we still have a 1-year grace period for an inventor's own public disclosure activities. The risk you take though when you publish before filing a patent is that somebody else can see what you've published, improve on it, and they're still able to file on that improvement invention, and you wouldn't be able to if you independently think of the same thing. This is one of the university's patents that I like to use as an example because we were able to convince the patent office that even though this was a relatively simple idea, simple invention, it wasn't obvious, and we were able to meet that non-obviousness requirement. So we used to have a faculty member on campus who was an expert in raptor eyesight, so how eagles, hawks, other birds of prey see. And so as humans, when we see, say, for example, a ceiling fan or a desktop fan on, the blades, when you're looking at it, when it's on, you can't see the individual blades because of motion smear. Well, however, these birds see blades of wind farm windmills against the sky. When they're looking at it, they can't see the individual blades because of motion smear. So he had the idea of painting patterns, different colors on the blades of the windmills in patterns or colors that are known for that these birds could see, and if they see it, then they wouldn't run into the blades and be hurt or killed, which it apparently is a problem. And so we got a patent on a method and apparatus of reducing avian collisions with wind turbines. The university licensed the patent to a wind farm company out west. The problem though, in order to get the pattern painted on the blades, they would only do it when it came time to servicing the windmills, which I don't know, what was once or twice a year. So they never really got a good sample size painted to see if this was really making a big difference or not. I think they probably found it wasn't making a big difference. So things don't have to work like you think they work ultimately for what we said in the patent application, but we were able to get a patent. I understand after talking with the inventor a few years later that someone thought, well, if they used paint with a certain UV signature, that would help. Well, apparently that had the exact opposite effect, since birds look for the UV signature of their prey's urine. And so that actually attracted them to some of these locations instead. In thinking about, though, when to patent, I think if you've actually made a prototype and can show that your invention works like you think it does, that might be a good time. Or even if you haven't made a prototype, but you can describe the invention sufficiently to enable somebody else to actually make the invention, you're potentially able to file a patent then too. But I think most importantly is that having a patent will add value to your product or business. You could file a patent on almost anything, but it's a really expensive investment. And so to consider, why file a patent? I think of patents as a tool for adding value to protect a potential product, to add value to a business. It might attract investors. I think that's the real reason to file a patent. Another thing that's important to think about is who proper inventors are on a patent. So inventors are people who contribute to the conception of the invention. Conception itself has its own legal definition. So it's conception is the formation in the mind of the inventor of a definite and permanent idea of a complete and operative invention. So just having an idea for something, but not knowing how to make it, does not make someone an inventor. I mean, I thought when I was 10 years old, I invented air-conditioned seats for a car. Well, I clearly had no idea how to make that. And even though then it came out years later in cars, I can't say I was an inventor. This isn't fair. An idea is sufficiently definite and permanent when only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. You can have multiple inventors on a patent. Joint inventors don't have to work together. don't have to make the same or equal amounts of contribution, and don't have to contribute to each claim of the patent. So a patent, for example, could be filed with claims to a device. We could have claims to a method of making the device, and we could have claims to a method of using the device. So say someone's working on a team, they join after the device is already made, but they are able to identify a new use for it and a way of working with the device to do something, do some other process. So as long as those process claims are still in the patent application, that person who contributed to that method of use would be properly named as an inventor too, even if that person didn't contribute to making the device itself. Another important question is thinking about who owns intellectual property. It depends. At the university, we look in each situation who the inventor or author is, where do they work, what does federal law say, what does university policy say, and are there any other written agreements in place that control who owns what. So that federal law piece is called the Bayh-Dole Act. So this lets universities own inventions that are made with federal funding. Before Bayh-Dole in 1980, federally funded research, the federal government kept ownership of those inventions that it was funding around the country. The problem, though, was that the federal government didn't have enough resources to help further develop these inventions and get them out into the marketplace. So the idea was, let's let the places, the contractors, the universities that are receiving the federal funds, doing the actual research, let them own the inventions, decide to own the inventions, and then they're closer to the ground, they have more resources to help further develop, de-risk a technology, get it licensed to companies who will do the further development and get these inventions to market. I think before Bayh-Dole, there's some stat, maybe 5% of federally funded inventions were being commercialized. After Bayh-Dole, it's more like 20 to 30%. So this law allows universities to own inventions made from federally funded research. We're encouraged to collaborate with companies to promote the use of university research, and we're encouraged to license these federally funded inventions to small companies, those with fewer than 500 employees, and we have to share licensing income back with inventors and use royalty income to further research activities. And so our University of Maryland IP policy memorializes this in the policy. We have a royalty sharing section which says what portion of revenue inventors get and what go to further promoting research. Any questions yet? Feel free to type in the chat. So under the university's IP policy, for inventions, software, where software, remember, the code itself is copyright, but the underlying functionality is potentially patentable, the method that the software carries out. So for invention software, even data and materials, students at the university would own that IP if made in the performance of their academic or research activities. But the university would own those things where it's made in the performance of sponsored research, and that's so we can comply with Bayh-Dole obligations, any other university administered research state funding or supported by university funds, or if made for personal purposes using significant university resources without permission, or if not owning would be a breach of contract. So I don't know how many students are on this, but when I do talk to students, I think a good way to think of it is if you're paying to come to the university, take classes, do research, if you're paying for it, you would own the IP, but then if the university is paying you, say if you're a graduate assistant, you're funded under a project, then the university would own that resulting IP. And we have a checklist too to help figure it out. So for university personnel and students, if IP was not created under sponsored research, was not created using other university or foundation funds, that includes gift money, and the IP was not created for personal purposes using significant resources without permission, and there's no other contract in place, then that personnel would own the IP. Students, though, would still own IP that they create, conceive, or make in the performance of their academic research activities, whether or not they use significant university resources. What does significant university resources mean? That is discussed in the IP policy. Generally, though, it means if you use a resource that everybody gets, so if you are talking on a university-provided phone, if everybody in your college is provided a computer and you happen to do something on that university-provided computer, that's probably not a significant university resource. But if you have access to specialized lab equipment that not everybody has access to, that would be an example of a significant university resource. Also, for faculty members, if you have grad assistants who you have as another resource to do work, do research in your lab, those students would count as a significant resource also, since not everyone gets grad students in that capacity. The right to use IP. So remember, as the owner, the patent holder has the right to exclude others from making, using, selling, or importing the invention. For copyright, the copyright owner has the affirmative right to reproduce, prepare derivatives, distribute copies, perform, display, transmit. Data and materials is a little different since raw data itself is not protected by IP. Materials is more of a physical property. So there's some IP rights, some contractual rights. But with these rights, the owner may grant permission to others to some or all of those rights. And doing that is a license. If someone is exploiting any of those rights without permission, that's infringement. The difference between a license and an assignment, so think of it like a house, a real property. So if you own a house and you want to sublet your basement to someone for a limited period of time, that's like a license because you're not giving them the whole house. They have some of your rights to enjoy and exploit for a certain amount of time. But if you sell your house, you no longer have access to it. You can't kick out the new owners if you don't like what color they painted the house. So that's an assignment or a full sale. And so the university, our goal is to license rights out, because then if our licensees aren't working to develop an invention, getting towards commercialization, getting the products of research out into public use, public benefit, we want to be able to pull the technology back and find a new partner to work with. Since we have a question about inventorship. So early on, I didn't list students, postdocs as inventors, since I alone generated the ideas and conceptualized the research, and that the students, postdocs just carried out instructions, right? So merely someone who just reduces the work to practice is not an inventor, that's correct. So if you're working in a lab and you're the lab director and you give instructions to the people in your lab to carry out something, make it correct. You're the inventor. They might have reduced the whatever it was to practice, but you knew how to describe it well enough. You had that concept, and we can go back to that definition of conception. So you were able to well enough describe it to your students, postdocs, to do the work. But if one of those students or postdocs, while carrying out your instructions, found that something wasn't working right, or they improved something, and that pivot or that improvement piece ends up in the final patent application, then that person should be listed as an inventor. And so now you've gone 180 degrees in the opposite direction and add everyone who's potentially listed. What's the happy medium? So I think a happy medium is thinking up front, especially when you're submitting a disclosure, who's contributed in when we're reviewing an invention disclosure in the office, at the initial meeting with one of our innovation managers, bring it up and have a discussion, and we can go through with you who did what. We'll ask questions, and things could always change as patent applications are filed, and even during prosecution. If claims, if you start with 5 people and 3 people contributed to a device, 2 people contributed to a method, but not the device itself, say the method claims are removed from the patent application, then those 2 people who only contributed to the method would not appropriately be named as an inventor on a patent that just claims the device. And so inventorship really is a legal question. We'll ask questions if you're not sure, and that's would be good for you to discuss with your innovation manager. But I think reasonably think about, who was part of discussions, even if it's not somebody in your lab, if you're having just, even just phone calls with a colleague at another institution and you're sharing ideas and you have weekly meetings and you're bouncing ideas back and forth, think about, who really contributed ideas to what the invention ends up being. And this can always change, and we know that it changes. So make your best efforts. I wouldn't overlist everyone. We have another option too on our disclosure form. If there's somebody who did a lot of work for you but might not have contributed conceptually to the invention, you can acknowledge them by putting them down as a designee, so that any potential revenue you get as an inventor, a portion of that can go to them, and that can show some acknowledgement. So we talked about rights to use IP. So licensing is our goal at the university. If someone is exploiting university-owned IP without permission, that's infringement. One exception to copyright infringement is called fair use. This is just for copyright, not for patents. So fair use is an exception that carves out an area where you can basically practice someone else and exploit someone else's copyrighted works without needing a license. So for critique, commentary, news reporting, teaching, scholarship, research, these are all areas where fair use is an exception to copyright making copies. Think of news reporting, if someone is giving a review of a movie and they want to show a clip of the movie, that would be fair use. But there are factors to consider and what courts look at to determine if something really is fair use or not. And I think you should consider this, especially now in the age of all online teaching. If you're providing course materials on, say, a course website, making a copy of a page or a short chapter of a full textbook might be fair use, but scanning in that whole textbook so that your students don't have to buy it, that might not be fair use. So look at the purpose and character of the use, including whether it's for commercial or non-commercial purposes, the nature of the work, the amount and portion of the work used in relation to the copyrighted work as a whole. That's my book chapter example. And effective use upon the potential market for value of the copyrighted work. So if by you copying someone's entire book and giving it to 3,000 students destroys their market for selling that book, that would lean against being a fair use copy. But remember, there is no fair use exception for patents. That's just for copyright. When licensing jointly owned IP, this is why we want to make sure we get inventors right, because then different inventors have different assignment obligations. So with patents, if a patent is jointly owned, each patent owner, joint owner, can license non-exclusively the patent rights to somebody else and can collect royalties and not have to share those royalties back with the other joint owner. That means that they don't have a duty to account. With copyright, though, there is a duty to account to joint owners whether or not you have an agreement. So when we get joint inventions or joint copyright, we always want to work out an agreement with the joint owner. that addresses who will take the lead on intellectual property protection and then how potential revenue and expenses will be shared. You might be given NDAs to sign if you're consulting agreements. If you're a student, once you go and work at a company, read what you're signing. I always read what I sign. And if you're not sure what something means, ask that question, because oftentimes companies might put IP assignment language in non-disclosure agreements. Publishing agreements, you have to be careful too. Say you've published your thesis through Drum. I can't recall who the electronic publisher is now, but at one point it was you had to assign the whole work, copyright the whole work to that publisher. And then I know it's common practice that people break up chapters and then publish individual chapters. And if you're then asserting to another publisher that you still hold copyright when you've assigned the whole work to another publisher already, that could be a potential issue. So pay attention to what sort of language is in these agreements that you're signing. Open source software. So open source software, an open source license is a type of language available for copyrighted works where the copyright holder, the author, is saying, I'm still saying I have the copyright in this, but I'm releasing it, licensing it under very generous terms. There's a variety of different licenses. Most open source licenses let others exploit copyright without having to pay any license fee back. You can make copies, make derivative works, distribute. With some of the licenses though, you have to carry down the license terms to any derivative work. You might have to give acknowledgement and then make sure that the same terms, some might prohibit commercial use, follow any of those derivative works. And here's a link that can help choose a license. If you're not sure and want to release something new, contact our office and we can help figure out the appropriate license. So what my office does, if you're not familiar, as the tech transfer office for the university, we take in intellectual property disclosures for IP that the university owns, and even IP if someone's not sure. Disclose it and we'll help figure it out whether we own it or if there's some other way we can assist. So we do the marketing. We try to find companies who have better resources to take something, further develop it, and get it to market. We do licensing and all sorts of agreements. So commercial licenses, non-commercial licenses, this might be agreements in the form of material transfer agreements, equipment loan agreements, data use agreements, where we're giving someone else permission to use this university property or intellectual property for research purposes only, and there might be some restrictions or not on what they can do with it. And then there's a way to come up with mixed models. We're seeing this now a lot with many of the PPE designs related to COVID masks and things like that, where people who are making new designs for 3D printing, for other sorts of manufacturing, are putting the designs out there to let others start to manufacture so that these things can get in use for protection, but it might be just for a limited period of time. And then after a year or two, then you start having to pay license fees or something like that if you're a manufacturer. Our office also provides startup support, these workshops being one, and providing other resources for if you're thinking about a startup company. We ensure IP rights. This is mostly through patenting. So if the university decides to pursue patent protection on an invention, we take care of the patenting process. We file some matters ourselves in-house. I'm a patent attorney, we have another patent attorney and another patent agent on staff. We also then take care of those government reporting obligations. So I mentioned the Bayh-Dole Act, where the government lets us own inventions made with federal funds. But we have all sorts of administrative work that we then have to report back to the government what's happening with the invention. what are we filing, and then if we decide not to pursue something, then we give the government an opportunity to take the lead. And royalty distribution, making sure the money that's coming in is going out appropriately. Another question that came in, what about open source hardware? So does that work similarly? Yeah, so I think if you are still, same idea, if you're publishing, if you want to put designs out there for hardware, how something's designed, how you build something, I think the designs themselves, you could release under an open source type license. You maybe call it an open access license. Or yeah, certainly things could be put out with certain language about what users can or can't do with, if you want to publish drawings or if you want to distribute hardware, how that works. And if you have questions about specifics, let us know. One thing came up on a webinar I was listening to today. Somebody wanted to release designs for something under a Creative Commons license, but the challenge for the university is these were designs of something that were going to be used in a patient setting. And so there's risks associated. Well, what if it really doesn't work? It really doesn't protect you like we think it will because there really has been limited testing. You want to be able to release it, provide it, but with limiting liability that you might have if something goes wrong down the road. So we can help come up with appropriate language to basically open source hardware devices, things like that. But the open source licenses specifically are really just for copyright. So as inventors, authors, creators, always important to keep good records, keep good lab notebooks. It helps to show that you actually invented something, when you invented it, if there's a question of somebody stealing from you. Emails, having documentation there if you're sharing ideas, back and forth. You always want to obtain applicable permissions if you're incorporating third-party works into your own, especially in publishing. Disclose timely to our office if it's a university-owned invention and you're planning to publish, or you've already published, but it's been within a year. Please disclose and we can help protect potential patent rights. As inventors, we want your help too in working with us through the patent process since you're the experts on the invention. We can help translate some of the legal terms and the complications and often painful process that patenting is, and keep us updated on your publication, public disclosure activities. And certainly formalize research and collaboration agreements. I know a lot of people are really excited and have great ideas now, especially in our COVID response, and are just sending things out of the university. If you've done that and maybe you sent out a design for something and are now having second thoughts that maybe this is something you want to protect, maybe work with a contract manufacturer, let us know and we can help paper those agreements appropriately. Please remember too that patents doesn't equal commercial success. There's a lot of patents out there, and I think majority of them, you won't see the product on the market or haven't made that much money. Disclosure to our office also does not equal an automatic patent. We try to do as best due diligence as we can and try to predict, one, what's going to happen if we file something with the patent office. And we do that by doing our own prior art search. So we try to predict, is the examiner going to give us a rejection saying this isn't novel or it's obvious, and working with our patent attorneys to come up with claims that we think are broad enough to build a fence around what our potential product is, but not so narrow that it'll be really easy to work around. And so if we can envision that any claims we get will be really narrow, it's probably not worth the expense of going through that patenting process, because it can be maybe $15,000 to get to an issued patent, maybe 10 or 12 for initial filing, 15 or more for prosecution, plus maintenance fees to keep it alive for the 20 years once the patent issues. And more importantly, we try to see is there a market for this, or do we think there will be a market for it in the near future? So if the market for something is probably not until 30 years from now, but a patent only lasts for 20, that might lean towards us not filing a patent. But if we think this is really groundbreaking, it could be added to a portfolio, or we have a licensee who's already interested, all of those things weigh towards filing a patent. I have a link here to where our disclosure form is. I'm hoping in the next fiscal year we'll have finally online disclosure forms. Right now it's a Word form, and feel free to email it in. We take everything electronically. And if you have questions about the form, let us know. We ask for basic things, who the inventors are. We let inventors, university inventors, say what your percentage split might be if there's potential income. If you're not sure, if you can't agree, we'll just split things equally. I mentioned the designee availability too. If there's people in your group you want to acknowledge, but they're not necessarily inventors, you can list them as designees. We asked for detailed description of the invention, any publications you have planned or have already made, and then any others working in the same area that we could contact for potential licensing. Lots of other great resources on campus. We're certainly working all virtual now at UM Ventures, and hopefully soon we'll get back to pitch competitions. I think there's virtual office hours happening through MTech now, and our EIRs also are doing some virtual meetings. MII, they're still taking applications. This is a proof of concept program funded by the state. So if you have an idea for an invention, especially if it's potential good candidate for startup, this is a short-term funding program for 9 months that helps with technology validation. Another question. Let's see, for patents filed by the university, those filing fees are paid for by the university, correct? Yes, that's correct. So what the university files on, we have a patent budget, so we'll pay those fees. Our patent budget, though, is limited, and so that's why often we have to make some tough decisions over what we can file and what we can't. But we generally file, I think, about 110, 120 provisional patent applications a year, maybe 50 to 70 full non-provisional applications, and those are what would issue into full patents. But we probably get about 200 disclosures a year that we have to assess and decide what we're going to file on and when. Let's see. Any other questions? Okay. So a question, someone's working on a project for capstone team in mechanical engineering on a team of 6 undergrads who may want to consider filing a provisional patent application. I'd certainly suggest doing that if you're considering patenting. I know there's design day. I'm not sure what's happening with that this semester, but design day normally is a public disclosure, and so that would be a patent triggering event. And so if you're not sure if you want to go for full patent protection, you can disclose to our office. We can help with filing a provisional patent application. Since you're undergrads, though, you would own the IP, not the university. If we decide to pursue the full non-provisional patent application, then we'd want a group decision that you want to go through the university. We'd ask that you assign rights to the university. And then if we decide to move forward, the university would pay for patenting. We'd try licensing, do our same assessment that we do for all of our other inventions. As a student, though, student group, if you decide you don't want to go through the university, the IP and Entrepreneurship Clinic, IPEC, out of the University of Maryland School of Law, they're an available resource too. They have law students who get credit for this. They can do help with prior art searches and filing provisional patent applications. So that's another resource for you as students too. Another question, no design day. That's too bad. Is there any online thing with design day? Wondering. Does UMD only file US patents, and what would justify international protection? So generally, if we don't have a licensee, we would just pursue US patent rights. For most things, the bulk of the market is in the United States. Foreign patent filing can get prohibitively expensive. And so unless we have a licensee or we think it will be licensed in the near future, then we may pursue foreign patent filing. Often what we'll do is we'll start with a PCT application, which stands for Patent Cooperation Treaty. And that's an international application that preserves potential worldwide rights, but lets you push off the expense until later than if you were filing directly in multiple countries at once initially. And so it gives you another year or so to evaluate the market, try to find a licensee who will help pay for the patent expenses. So if we see a good reason, there's a company, they have a pipeline in another country, they're potentially going to manufacture there, depending on what industry it is, we might file there. But some of the big regions for filing, Japan's really expensive because you need translations. Europe can get very expensive as well because you have to pay annuity fees every year just to keep the application going. Brazil now, especially for ag technologies, is a popular place to file, but again, you need translations and those add to the expense. Other countries are less expensive to file in places like Canada, Korea, but again, we have to evaluate what the market is, and generally US is sufficient for most of our inventions. Another question, when using royalties toward research, can a restriction be forced upon the university in regards to the type of research the royalties can be used for? No, so in our IP policy, the revenue distribution sharing scheme under the current policy, when money comes in, once we've recovered our unreimbursed expenses, so if the licensee isn't directly paying for patent costs, once we have license revenue, 50% goes directly to the inventors, 25% we keep to help support our operations, which really goes back into our patent budget, and 25% goes to the departments, and it's the chair's discretion how that money is used. It's supposed to be used for research. So I know some departments, the chair will direct it back to the lab of the person whose technology it came from, but they might use it in other ways. Our office doesn't have a say on that. Our previous policy, I had a tier in it that then if we brought in, I think it was more than $100,000 of revenue, then the VPR, the Vice President for Research, could allocate money differently. But, excuse me, there is no such cap in the current policy. And so that 25% department share, that's what's intended to further promote more research. And so it's under the chair's discretion. So if royalties came in on a cancer drug, would we be able to then say those are restricted funds to cancer research? No. Happy to take more questions. And I know we're doing, I don't know if anyone participated in the Division of Research's town hall, I think that was last week.